All right, thanks so much for being with us here on ANF Plus. I'm Joy Lim Nakron, and I want you to know that you are looking live right now inside Fulton County Superior Court, and this is where the YSL RICO trial is now getting back underway. Of course, there was a recess. We're coming back after lunch. You can see that Paige Reese Whitaker is now on the bench, and the parties are re-entering the courtroom as well. And we've been covering this case extensively. Of course, we've been bringing you gavel-to-gavel coverage here on ANF Plus, but this has become an even more important story in recent days because Judge Paige Reese Whitaker has been weighing the possibility of a mistrial. And in addition to that, there have been several defendants that we understand have actually met with Fulton County District Attorney Fonnie Willis to discuss the possibility of plea deals. So I want to let you know right off the bat, if you want to watch our coverage inside the courtroom live, you can do that on our Courts and Trials channel and also on YouTube here, on our multi-platform array of what we have for you to watch here on Atlanta News First and Atlanta News First Plus. But if you want to stay with us right now for analysis, I want to bring in a very special guest and really a favorite here on Atlanta News First. We have criminal defense attorney Josh Schiffer joining us, based here in Atlanta. Thank you so much for being with us, Josh.
Thank you so much, Joy. And is this exciting or what? I can't even figure out what to pay attention to.
and here's the thing, we have covered this trial for almost 2 years now. I mean, it was January of 2022, really, when this whole thing began with jury selection. And here, well, I should say 2023. But now, we're just a couple months off from January 2025. That'll be the 2-year mark. And now we're talking about the possibility of a mistrial, which would essentially bring this whole thing to a screeching halt and potentially hit the restart button where we'd have to start from scratch again, right?
It's a trick-or-treat bag filled with a whole bunch of surprises, and we're figuring this out literally live right now. They are meeting in court right now to deal with whatever announcements have been decided on over the last several days. Just to bring everybody back, last Wednesday, Judge Whitaker talked about this mistrial issue, and it was clear she wasn't going to offer a mistrial with prejudice that would prevent the DA's office from retrying the case, but a mistrial without prejudice was definitely on the board. That's the judge telegraphing to everyone, hey, y'all need to get together and meet. So that's what they've spent the last several days doing. Unfortunately, we don't have very many absolutely confirmed details. No one does. Anybody telling you they've got the inside track is lying, and I'm telling you that because I know all of these people. This is locked down for all the right reasons. There has to be secrecy, confidentiality, and security during these kind of momentous bits of trial evolution. What I can tell you absolutely without a doubt is that there have been discussions. Those discussions went all the way to the top with everybody involved, including DA Willis. We don't know the result of that, even though at least one lawyer for one of these co-defendants has recently come out in the last 15 minutes, Doug Weinstein, announcing that his client, DeMonte Kendrick, will be going to trial, was not going to be entering a plea. That's what his tweet suggests. We're looking at the judge now apparently doing something with the Rule 22s. That involves media coverage. I guess the judge is upset that certain recordings are getting made in the court. Don't have all the details on that. But we know that at least one of the co-defendants will be continuing with the trial. That doesn't mean we don't that the others can't enter a plea.
Yeah, absolutely. So DeMonte Kendrick, you mentioned Yak Gotti, but we understand that there could potentially be plea deals for a couple of other defendants. We understand that multiple defendants have been meeting with Fulton County District Attorney Fonnie Willis's team really in the last week or so, discussing the possibility of plea deals. And so that's a whole other thing that could essentially bring the trial to a halt if not for those particular defendants. Maybe the trial would continue, but it would be the end for defendants who reach a plea deal, right?
And that's such the rub, because you're absolutely right, Joy. If one or more persons takes a plea, that's their right. You can really do that at any time during a trial. You can stand up and say, Judge, I want to take a plea. Now, whether that plea is negotiated or non-negotiated or what, that doesn't matter. But you can enter a plea. If you've entered a plea, the trial against you stops. When you enter a plea, you give up all your constitutional rights for this set of charges, and you subject yourself to the jurisdiction and the punishment of the court. But the rest of the trial for the rest of the charged individuals would continue. It doesn't stop, but changes the dynamics tremendously.
Yeah, absolutely. And, one of the unique features of a RICO trial is really the size and the number of the defendants and the scope of it and, the number of events that you can tie into it. And again, co-defendants.
Yeah.
So, and witnesses, right? And so when you start losing people as part of the trial, that really changes the nature of the trial.
Absolutely. If there are people that enter pleas that had specific overt acts attributed to them that the state needed to prove, those parts of the trial would no longer be necessary. And by removing those parts of the trial, there's an impact on the other co-defendants, perhaps, because now those co-defendants aren't going to be associated with something the jury doesn't see. And if certain defendants are removed, that could dramatically shorten the state's presentation in this case, which is an issue both Judge Glanville and Judge Whitaker have extensively harped on. Hey, DA Love, we need to reduce the number of witnesses. We need to reduce the time this is taking. We need to make this more discreet and efficient. Entering some pleas is a good way to do that because it would remove a couple individuals, decrease the complexity, and make it more efficient. That being said, effectuating, negotiating, arranging a plea in a case like this, unbelievably complex and time-consuming. Just the communication that you are supposed to have with your client, confidential and secure, arranging that in a courtroom setting that's this busy and packed, it just takes a lot of time. And I know that that's what a lot of this is, these last couple of days have been spent on, communicating the complex mathematics, the calculus that goes into anyone accepting responsibility for the charges and entering a plea or deciding to continue the trial.
Yeah, and, we've talked a lot about the possibility of plea deals, but what's also garnered a lot of attention is the possibility of a mistrial. But, I mean, it is really important to emphasize that there have been several calls for mistrial. There have been several motions for a mistrial throughout the course of this trial, and the trial has continued.
Absolutely. There have been dozens of mistrial motions, some of which were a little bit more, easy and convenient, some of which have been very thoroughly presented, and those are cumulative. If this case does reach a verdict, and a verdict would then be sent for review during the appellate process to the Court of Appeals, who would be tasked with then investigating these motions for mistrial. Did the judge make a mistake in denying one of those motions for mistrial? Now, that's only if the case actually reaches verdict. One of the benefits that Judge Whitaker is particularly connected to is the idea that with pleas and non-verdict resolutions of this case, it dramatically decreases the amount of appellate issues that could flow from this now 2-year prosecution, the longest and most complex case of any kind in the state of Georgia's history.
Right, right. And so we just saw that live shot of Paige Reese Whitaker back on the bench again. And again, this is the third judge now in this trial, and it is really worth noting that Ural Glanville, the very first judge in this case, was recused. And also, that surrounded some mistrial motions, right? I mean, there were accusations of bias by Ural Glanville, and because of that, the defense motion for a mistrial. And so here we are again talking about a mistrial for a different reason. And you were here on ANF Plus when you provided some great analysis of why Judge Whitaker was considering a mistrial, said that she was considering a mistrial after one of the witnesses on the stand read something that was supposed to be redacted. That free quay, which the defense argued really implied that some of the defendants had spent time behind bars.
Bad character evidence. Yeah, right. That bad character evidence. And that's the kind of stuff that worries both Judge Whitaker as well as the DA, because the DA has an obligation to present this case as cleanly and as bulletproof as possible. Unforced errors, such as that introduction unsolicited of character evidence that was not supposed to be allowed, that's one ding. But then when you combine it with the totality of circumstances where there have been very specific and salacious allegations of wrongful biases, specifically between Judge Glanville and the state. Now there are some involving Judge Whitaker and the state, all of which have been noted by the defense. All of the different defense attorneys have brought it up at one point or another that the state is being favored by the judge. If there is a non-verdict resolution, those concerns don't make it to the Court of Appeals. at least not in a trial setting. So there's a lot of people would say Judge Whitaker has a big incentive to try to end this prior to any kind of verdict. A mistrial is definitely on the table. She telegraphed to all of the parties that she was strongly considering a mistrial without prejudice, and that is a prescription for more work, effort, asset allocation, and time involvement. A case that took 2 years to get this far, how long would it take if they tried to do it again? What would happen to the accused during that pretrial time? Remember, Jeffrey Williams doesn't have any prior convictions, and he's been held in the Cobb County Jail on behalf of Fulton County now for the entire length of the trial, as well as the other co-defendants. There's a substantial cost in just money. But then there's the bandwidth in the DA's office. That DA's office is very busy. There's no lack of cases to try in Fulton County, and a complaint amongst the judges, as well as the rest of the criminal defense bar, is that these high-profile, incredibly intense cases are detracting from the mandate to prosecute the rest of the cases out there. Now, that system slowdown has been made big hay has been made out of that by Fani Willis's challenger in the election, which, remember, is next Tuesday. And Fani Willis faces Courtney Kramer, a local attorney in the race for DA, and Ms. Kramer has focused specifically on the YSL trial as a main campaign plank, even having gone as far as to promise she would dismiss that case if elected.
So I think it's also worth noting that the prosecution still has dozens of witnesses that they're planning on calling in this case, and then we're talking about just the state's case, because you and I, we met at Court TV, but the average person who's watching right now, I'm not sure if they're familiar that the state presents their case, then the defense presents their case. I mean, the state still has a long way to go before we can even talk about that second part where the defense presents their case and then closing arguments and then jury deliberations and a verdict. So I mean, if a mistrial is not granted, if this trial continues, there is a very, very long road ahead. But if a mistrial is granted and then the whole thing is started again, there's an even longer road ahead.
Yeah, colloquially, we're not even at the halfway point of this trial. And you're right, Joy. The state indicated previously that literally hundreds of witnesses were going to be called on behalf of the state in this case. The court has forced the state to pare down that list substantially, but we are still looking at dozens and dozens of additional witnesses over a period of weeks before the state is ready to rest their case in chief. Then we would get to hear the individual defenses of each and every co-defendant. We're talking about months of witness testimony, expert witnesses, physical testimony being introduced, and all the arguments that those would cause. So we can't even estimate the additional resources that would be necessary to try this case fully and completely with all the co-defendants as situated. Any removal of a co-defendant through a plea or other disposition benefits the state by reducing the complexity of this case, arguably would make it be more difficult to defend because the defendants generally benefit from the more complexity they can add to any set of charges. No one's even thinking right now about this poor jury who has also been out since last week. They had court ended abruptly. They were told not to return, and only now we are hearing about potentials for court restarting. We're obviously watching the hearing right now. They just began at 1 o'clock, waiting to hear exactly what the announcements are going to be. However, my latest is that I expect the trial to resume against at least some of the co-defendants here, presumably tomorrow.
And I just want to share, just into our newsroom, we've learned that there's two Quays, right, in this case that we've been talking about, but Quay Marvius Nichols is taking a plea deal. That's, again, just into our newsroom just moments ago, taking a plea deal and has been charged with the 2022 murder of Shymel Drinks. But again, Quay Marvius Nichols, a.k.a. Quay, but there's two, people who are, two defendants who are a.k.a.
Two Quays.
But Quay Marvius Nichols, we understand, just moments ago, has agreed to a plea deal. Obviously still working to get the details there, but this is what we're talking about. This is something that is going to impact the other defendants. It is going to impact the trying of this case, and really reduce the size of the case, which some might argue is a bad thing, some might argue is a good thing.
And the most important part is it shows movement, and movement triggers more movement, because as the other co-defendants reassess the strengths and weaknesses of their case, just like the state is going to do, with the change in tone from Mr. Nichols. Looks like he's entering a plea, from what we're seeing, to about 7 years of service and a good chunk of probation, with the murder getting dismissed. A lot of clients would consider that a big win. But we have those other issues involved. Is he going to be forced to agree to certain facts, like we have seen with Monktunk and some of the other individuals who have been convicted in this overarching prosecution? Now, to remind everybody, Monktunk, when he appeared and testified, did not testify according to the terms of the deal that he had struck with the state, despite the efforts of his wonderful lawyer. That caused a probation revocation, and Monktunk was trundled off to a 5-year revocation about a week ago. That is after receiving what is mostly considered a straight probation sentence. I think it was about 30 years. That's kind of the sausage that we're talking about when we get to pleas. It's not just the time, it's the other associated stuff that goes along with it, such as promising to tell the truth, acknowledging that YSL is a gang, which is a giant issue for the DA's office. They want to establish more than anything that the DA's office was correct in asserting that YSL is a criminal street gang, that the people involved are gangsters, and they deserve prosecution. In polar opposite from the defense position that YSL is a recording group, that it is a business, and that all of the rap lyrics and the other issues are just made up in licensure of art. Clearly a tough cultural issue for our community to face.
Yeah, so I want to ask you, if now we know that one of these defendants has reached a plea deal, but we haven't heard about a mistrial ruling, can we glean anything from this new development regarding the plea deal?
I would think that if a mistrial was highly likely or being discussed, because remember, that's the judge's call. Both the state and the defense can weigh in and say, Judge, we want a mistrial in this form for this reason, and they can collaborate on that if they want it. The state and the defense could get together and say, Judge, we mutually recognize these problems and want a mistrial. That's not really likely. The defense doesn't want a mistrial unless it comes with prejudice, thereby prohibiting Fani Willis from prosecuting these co-defendants, whereas the state wants to preserve their ability to seek justice and convictions against these co-defendants.
Did you say the defense would not want a mistrial unless it was one with prejudice?
Yeah,
Okay.
in all likelihood, the defense would be objecting to a mistrial because the defense rationally and reasonably believes they have the upper hand when it comes to the legitimacy of this trial. They understand that should there be a verdict of conviction, there are more appellate issues to tie up the Court of Appeals forever. And that means that their client still preserves a pathway to non-conviction. You can also have bonds, like supersedeas bonds, while a conviction is being, reviewed by the Court of Appeals. And an appeal really pulls back the sheet and shines some light on the actions of the state and the defense, which could cause substantial embarrassment. As some people have mentioned, one of the individuals that the state has called, there's a prior opinion with that individual called out by name for violating basically what you're supposed to be doing as a DA, and is castigated by our appellate courts. That's the kind of stuff that the DA's office is going to try to avoid. They don't want egg on their face. Fani Willis has to show up and show all of these voters that she made good judgments and that these resources were allocated properly. That's a big question in a lot of voters' minds.
Yeah, absolutely. And just a reminder for our viewers who do want to watch what's happening in court, you can do so live on our Courts and Trial channel and also on YouTube. And we are, again, bringing you gavel-to-gavel coverage of this historic trial. Again, this is the longest-running criminal trial in the history of Georgia. And it keeps getting longer, quite frankly, especially with no mistrial declared at this point.
It's rule-breakingly historic. There's so many academic issues you can think about. Is it possible to have a fair jury that lasts 2 years with this many interruptions? Is it fair to ask jurors to serve like this? Is it fair to have someone be in a pretrial custody for something of this length? Was the bringing of these charges rational and reasonable and good judgment from the state? or, as the defense suggests, bringing these charges in the case in the way that the state did is abusive in its very creation. These are fundamental justice issues that our nation has fought with since our founding. There are no perfect answers. The best thing about our system is there isn't a better one out there. Even with all of the traumas, the tragedies, the successes, and the sins that we see in criminal justice, it is the best system out there, and it's aspirational in its improvement. We fix the mistakes through the Court of Appeals, and then we keep making our trial process better. This trial is going to be a lesson for the entire nation for years to come.
Absolutely. Attorney Josh Schiffer joining us here live with analysis. And again, for our viewers, if you haven't done so yet, I really encourage you to download our free Atlanta News First app to get updates sent right to your phone. Also, you can check out the latest on atlantanewsfirst.com. But also, if you want to look live, let me show you our live stream into the courtroom where we have the seal up right now. And that means that we can't show you what's happening live. Otherwise, we would, and we would let you listen in. Sometimes there are moments during court where the judge is addressing attorneys outside the presence of the jury, going off the record, and so obviously we're not allowed to stream the contents of those conversations. But if you want to watch everything that is happening inside the courtroom, gavel to gavel, go over to our Courts and Trials channel or on YouTube as well. Thanks so much, everybody, for joining us here on Atlanta News First Plus. And again, please download our free app to get the latest right on your phone. And for now, back to local.